Assistant Bar Counsel here at the Cleveland Metro Bar Association. Thank you all for coming today to our September Hot Talk on Supreme Court nominee Brett Kavanaugh. Our Hot Talks are held the second Tuesday of every month. The idea here is to create open dialogue on various topics, sometimes political, sometimes not. So like I said, second Tuesday of every month. Our next one will be October 9th. If any of you have any ideas for Hot Talks, I know Daryl Clay and Marlon Primes are in the audience there on our Thought Leadership Committee, as well as Heather Zerke and Becky McMahon. Stop by and let us know if there's a topic you'd like to discuss, and we can put it on our list. Today, I am going to introduce Magistrate William Beaudry. He's been a magistrate of the Cleveland Municipal Court since 2001. He previously served as an assistant Cuyahoga County prosecuting attorney from 1995 to 2001, and a staff attorney of Southeastern Ohio Legal Services in New Philadelphia. He is also on the CMBA's Character and Fitness Interview Committee, the Bar Admissions Committee. He graduated from Oberlin College and then Case Western Reserve School of Law. He's been admitted to the bar of the U.S. Supreme Court back in 1997. He has long studied the court, and this is what brings him his interest today. So I will leave it to you now.
Thank you so much. Thank you. In fact, I still remember the day of my admission very clearly. It was near the end of the term, 1997. Justice Breyer and Justice Ginsburg, who's definitely been in the news lately, made the round of the room. It was, as I said, towards the end of the term, and Justice Ginsburg very briskly worked the room, and I was near the door as she left, and she said, "Back to work." A woman with a mission, on a mission, clearly. Well, we're here today, no big surprise, to talk about the Kavanaugh nomination. And I want to put a bit of perspective and suggest to you that perhaps Justice Kavanaugh is maybe not the most important story here. With Judge Brett Kavanaugh's confirmation in the Senate Judiciary Committee now behind us, the U.S. Supreme Court is, of course, once again, headline news. Not that it's ever too far from those headlines. If Judge Kavanaugh is confirmed, he'll probably bolster what is usually considered the court's conservative majority, being generally regarded as more reliably conservative by a political friend and foe alike than the man he once clerked for and who will now succeed, Justice Anthony Kennedy. And as it happens, many of you may know Justice Kennedy swore in Judge Kavanaugh to the D.C. Circuit back in 2006 when he was nominated and eventually confirmed. But the person whose life might change more than anyone's if a Justice Kavanaugh takes the bench is quite possibly John Glover Roberts, the Chief Justice of the United States. To see why, let's consider the post in a historical context. I start with first principles, the Constitution itself. The Chief Justice is the only judicial officer specifically mentioned in the Constitution, but even so, he, or someday she, is mentioned only once in Article 1, Section 3, Clause 6. Not even Article 3, as you might expect, but Article 1. The Senate shall have the sole power to try all impeachments, and when the President of the United States is tried, the Chief Justice shall preside. Only reference to the Chief Justice in the entire Constitution. Article 3, as I said, doesn't mention him at all, but Section 1 provides the judicial power of the United States shall be vested in one Supreme Court and in such inferior courts as the Congress may from time to time ordain and establish. The Judiciary Act of 1789 puts the meat on those bones, providing for a court comprised of, anybody know at the outset? Seven. Actually six. Right? The Chief Justice and 5 Associate Justices. There you go, a built-in tie. Could have 3 and 3. The size of the court has certainly varied since then, rising to as many as, anybody know? At most, 10 in 1863, before settling again in 1869 at the 9 it still has. As my teenage son was astonished recently learned, Congress could increase the size of the court any time it chose. It's not a constitutional issue, as FDR sought and failed to do in 1937. From all of my fellow law nerds, a necessary reminder. John Roberts is not the Chief Justice of the Supreme Court. The correct title was and is actually the Chief Justice of the United States. This is largely due to the efforts of Salmon P. Chase, an Ohioan who was appointed Chief Justice by President Lincoln in 1864. Chase had a bit of an ego, I think it's fair to say, and he wanted a grander title than it had originally been. So he dubbed himself Chief Justice of the United States, and thus not just of the Supreme Court itself. Congress went along shortly afterwards, and later Chief Justices have all borne the modified title. So if you want to be cool, if you want to show people just how in you are with Supreme Court lore, it's the Chief Justice of the United States. On the Supreme Court, the Chief Justice is primus inter pares, first among equals, but he's not the boss. The current title, found in 28 U.S. Code 1, emphasizes the Chief Justice's role as a leader of the judiciary, a co-equal branch of the federal government. The Chief Justice has additional responsibilities as well, you may know, customarily but not invariably, including swearing in the president. When Chief Justice Roberts, first time out, swore in President Obama in 2009, many of you will recall they followed the oath and decided in an abundance of caution to have a do-over at the White House the next day. By heading the Judicial Conference of the United States, the Administrative Office of U.S. Courts, and the Federal Judicial Center, the Chief Justice exerts a supervisory role. Professor, welcome. Supervisory role over the entire national federal judiciary. Under 1922 law, he can also, with their consent, assign federal judges for temporary duty as needed around the country. Under more recent legislation, he selects judges for service on such specialized panels as the Foreign Intelligence Surveillance Court. And since 1846, show of hands, how many of you knew this? He also serves as Chancellor of the Smithsonian Institution. It's nominal but largely honorary head. Okay, who knew that? Any Smithsonian? All right, there we go. Maybe the professors. If you read the masthead of Smithsonian Magazine very closely, you'll see his title, but not by name, there. Sometimes the Chief Justice is given still other assignments. John Jay and John Marshall both served briefly simultaneously as both Chief Justice and Secretary of State. In 1794, at the request of President Washington, John Jay led the diplomatic mission that negotiated a controversial treaty with the British that resolved much of the unfinished business of the American Revolution. And more recently, in 1963 and 64, Chief Justice Warren headed the commission bearing his name that investigated the assassination of President Kennedy. John Roberts is the 17th Chief Justice. He's had some illustrious predecessors, and some who were, let's say, not so illustrious. But particularly noteworthy, I would suggest to you, were John Jay, the first Chief Justice, whom, as I mentioned, was a former president of the Continental Congress, governor of New York, a co-author of the Federalist Papers, and a noted diplomat. He set the court on its journey, although the court, not exactly overworked, decided how many cases in his 6 years as Chief Justice? 4. 4 cases. It's changed a little since then. John Marshall, the 4th Chief Justice, more than anyone else in the new republic, assured the court a co-equal place under the Constitution. He led the court to its unanimous decision in Marbury versus Madison. Everybody reads that, first year of con law. In 1803, establishing once and for all the principle of judicial review, not actually found in the plain text of the Constitution. Marshall insisted that his fellow justices live in the same Washington, D.C. boarding house, building collegiality and making unanimous decisions more likely. He wrote nearly half of the court's decision in his 34 years leading the court, still a record. Roger Taney, a Jacksonian Democrat who led the court for 28 years and is still best remembered for Dred Scott versus Sanford in 1857, which has, understandably enough, overshadowed everything else he did. Dred Scott declared that slaves were not U.S. citizens, had no standing in federal courts, and that Congress lacked authority to even regulate slavery in U.S. territories. The decision has gone down in history as still, despite many contenders for the title, as probably the worst Supreme Court decision ever. There's the aforementioned Salmon P. Chase, former governor of Ohio, former U.S. Senator from Ohio, Secretary of the Treasury in President Lincoln's cabinet, who angled for the 1864 Republican nomination but didn't get it. Lincoln didn't hold a grudge, though, after accepting his umpteenth resignation, and he appointed Chase as Chief Justice later that year after Taney's death. Under Chase's leadership, the court dealt with the legal aftermath of the Civil War in such cases as Texas v. White, holding secession to be illegal, and Ex parte Milligan, limiting the president's war powers and asserting the court's relevance even in times of grave national crisis. Chase presided over Andrew Johnson's impeachment trial in 1868 in the Senate, the first Chief Justice to do so. While still serving on the court, he tried again for the presidency in 1868, but once more fell short. William Howard Taft served on the Sixth Circuit for 8 years and in a variety of federal executive posts before being elected president in 1908, thanks largely to the support of his friend and political ally, Theodore Roosevelt. Taft yearned to go back on the bench, though, and 8 years after leaving the White House, after a single undistinguished term, was named Chief Justice in 1921 by his fellow Ohioan, Warren G. Harding. Taft, the only former president to serve on the court, led it for almost 9 years and is perhaps best remembered for finally persuading Congress to pay for a new home for the court. The court finally moved out of the basement of the Capitol. Oop. I'm going ahead myself. Finally moved out of the basement and into its own building in 1935, 5 years after Taft died. Chase and Taft, of course, would be proud of as fellow Ohioans. Earl Warren was a former Attorney General and Governor of California, as well as Thomas Dewey's running mate in the 1948 election. Dwight D. Eisenhower considered his support key to winning the 1952 Republican nomination for president and felt obliged to appoint him to the first vacancy that opened on the Supreme Court, which happened to be that of Chief Justice, after Chief Justice Fred Vinson died. Warren led a virtual revolution on the court for individual rights and criminal justice reform, including such notable cases as Brown v. Board, striking down school segregation, Gideon v. Wainwright and Miranda versus Arizona, protecting and expanding the rights of those accused of crimes. Nicknamed Super Chief, he remains the exemplar of progressive judging for many Americans. William H. Rehnquist was arguably the conservative equivalent of Warren. For some years, the most notable right-leaning associate justice on the court, he was elevated to the top spot by President Reagan in 1986 and led the court in a distinctly conservative direction. In U.S. versus Lopez, for instance, the court set the first limits on Congress's Commerce Clause powers since the New Deal. His hostility to Roe versus Wade was made repeatedly evident, perhaps most notably in Planned Parenthood versus Casey in 1992. In 1999, Rehnquist became only the second Chief Justice after Chase to preside over a presidential impeachment trial in the Senate when Bill Clinton stood accused after the Lewinsky affair. Chief Justice Rehnquist died in 2005, which brings us to John Roberts. Judge Roberts, at the time, on the U.S. Court of Appeals for the D.C. Circuit, was nominated to fill the seat actually of Justice Sandra Day O'Connor that year, but when Chief Justice Rehnquist died, President Bush withdrew that nomination and promptly nominated Roberts for the Chief Justiceship instead. He was relatively easily confirmed and has led the court ever since. Some key decisions in which Roberts wrote or joined the majority of opinion have included Gonzalez versus Carhart, upholding the constitutionality of the partial birth abortion ban of 2003, District of Columbia versus Heller in 2008, for the first time finding an individual and not a collective right to bear arms under the Second Amendment, and of course, Citizens United versus Federal Election Commission, striking down restrictions on independent campaign expenditures as violative of the First Amendment. And in National Federation of Independent Business versus Sebelius, a case near and dear to Professor Adler, I know, Chief Justice Roberts, to the surprise of many, provided the fifth and decisive vote to uphold Obamacare, although with restrictions. Some of you doubtless have your own favorite or most loathed examples of the Chief Justice's jurisprudence. But what will the Justice Kavanaugh mean for the Roberts Court? Most crucially, it might make the court, now and for many years to come, actually a Roberts Court. That is, one in which the Chief Justice is in the majority far more often than not, and one which he might very well lead to be more consistently to the right. Although Chief Justice Roberts has only one vote when deciding cases, just like his 8 colleagues, he's automatically the senior justice, even ahead of those who've been on the court far longer. Crucially, absolutely crucially, he assigns the writing of decisions to whomever he wishes when he's in the majority, including, if he likes, to himself. A court which has long been narrowly divided on some hot-button issues, including abortion, law enforcement and the rights of the accused, gun control, immigration, affirmative action, and free speech, among others, could be more consistently reaching 6-3 rather than 5-4 decisions. After almost 13 years of at least nominal leadership of the court, this would make Chief Justice John Roberts, who can either write those decisions or handpick those who do, even more important, even more influential than he already is, which is saying something. Thank you. It's my pleasure at this time to introduce our fellow panelists. First, I'll lead off with Professor Doran Kalir, who teaches federal courts, contracts, professional responsibility, and appellate clinic at Cleveland Marshall College of Law. He writes about the Supreme Court and the interface between law and religion, as well as LGBT rights. As a clinical professor, he represents unprivileged clients at all levels of the Ohio State courts, from municipal court in Defiance to the Ohio Supreme Court. He's represented clients at all levels of the federal system, including the U.S. Supreme Court, and before the immigration courts, both at the trial level and before the Board of Immigration Appeals. Before arriving in Cleveland, Professor Collier worked nearly 5 years in one of New York's largest law firms, Skadden Arps, and studied and taught as an adjunct at Columbia Law School. Before that, he studied and taught law in Israel, where he also served as a clerk to then judge, later Chief Justice of the Israeli Supreme Court, Miriam Nahor. He's also completed 3 years of service in the Israeli Defense Force. Please join me in welcoming Professor Collier.
Thank you, Judge.
You want to stay seated and take a vote?
Oh, there's the computer there. I'll stay here. Can you hear me? All the way to the end, Becky? Okay. Oh, thank you. Thank you so much for this historical introduction. I'll be brief and I'll make just 3 points regarding the nomination of Judge Kavanaugh. The first will go back, the second will deal with the present, and the third with the future. Let's start with the history a little bit, although we had a very good lesson a minute ago. We have here, we're dealing with a stellar candidate with stellar academic credentials with an entire Yale Law School, most of it standing behind him, which is the #1 law school in America. This is a candidate who worked furiously for one Republican president, only to be then nominated by another Republican president. And this is a nominee who's well-known views on abortion rights, gun control, and presidential powers are well-known, but places him far to the right of some other viewers of the court. Of course, there was a lot of import on this nomination, and one of our greatest constitutional scholars wrote this about this nomination. Kavanaugh appointment, if confirmed, promises to achieve the dominance of the right on the Supreme Court that Trump previous appointments failed to secure. For Justice Kennedy has been the swing vote, siding mainly with the right on the issues of criminal law, but with more liberal justices on other issues of individual rights. And he has provided the fifth and crucial vote, one way or another, on many occasions. If Kavanaugh votes, as those who support him in every reason to expect that he will, the court will have lost the balance that Kennedy provided, and will have lost the opportunity for cases to be decided one by one on the issues rather than on those simple ideological tests. So the Senate should not apply the relaxed standards it does when President seeks merely to have his own constitutional philosophy represented in the Supreme Court, but rather the Kavanaugh nomination is the climactic stage of a very different presidential ambition to freeze that institution for as long as possible into an orthodoxy of the president's own design. I said that this is an historical comment, and these lines were written 31 years ago by Ronald Dworkin, who's unfortunately passed, and they were written on, of course, on Robert Bork, whose nomination frighteningly mirrors the nomination we have here today. In fact, some would argue, not Professor Osler, but some would argue that Bork would blush if he would know the actual views that the current nominee, Kavanaugh, takes on abortion, gun regulation, and presidential power. Just for a flavor, here is Judge Kavanaugh dissenting from an en banc decision of the DC Circuit Court, who's headed by whom? I forget. Who's the chief judge there? Mary Garland. Thank you. And that is important because you see here where we're going. Is descending from the decision to allow an immigrant minor imprisoned female to have an abortion. Here he is descending. I'll give you just one word here. The en banc majority has badly erred in this case. So if you think about the insular and distinct minorities that the court needs to protect, we have here a minor, an immigrant, an imprisoned female who's in dire need of medical help and abortion. Government has permissible interest in favoring fetal life, writes Kavanaugh just a few months ago, protecting the best interests of the minor, it's not yet alive, and refraining from facilitating abortion. The constitutional principle that the majority is based on is as novel as it is wrong. A new right for unlawful immigrant minors in the United States government detention to obtain immediate abortion on demand. So this is the right for abortion for a person who, of course, testified in its precedent on precedent, Roe v. Wade. He descended also from the Heller II, after the court in 2008, as Judge Rodriguez just mentioned, affirmed the individual right to hold and bear arms. Heller II came before the court to say, is the regulation okay? And just like Scalia said, in his opinion, and the majority, and most of the DC Circuit, again, headed by Mary Garland, said, of course, regulation is fine. Here's what Kavanaugh has to say. In my judgment, both DC's ban on semi-automatic rifles and its gun registration requirement are unconstitutional under Heller. We all know what Judge Kavanaugh actually thinks about inquiry and criminal investigation of a presiding president. He actually wrote this in the Minnesota Law Review article. But more interestingly is what, and that was well known during the hearing, you all wrote or heard about that. What was more interesting to hear is about what he thinks about judicial appointments to the Supreme Court, which he wrote on in the same article. And he says, as for judicial appointments, structural considerations favor a more intensive inquiry by the Senate. Article 3 judges are appointed for life and, unlike executive branch officials, are not subordinate to their appointing presidents. That changes the constitutional dynamic. The president deserves great deference in the selection of his own subordinates, who, after all, must follow the president's lead and are accountable for the president, who is responsible for their actions. By contrast, the independence and life tenure of federal judges justifies a more searching inquiry by the Senate into the fitness and qualification for his office. And so here we have a person who wrote that you need a more searching inquiry when you're coming to a lifelong service on the United States Supreme Court. But when asked any question, you all saw that, I hope, in the 4 days in the book, he refused to answer on the basis that it may come before the court, and it's an hypothetical. Sorry. It died. Thank you. Which brings me to the second point, which is the what Justice Kagan called the vapid and hollow charade that is called today the nomination process. And Vice President Joe Biden called it the kabuki theater when he was the Chief Justice there. It's really a shame that at the point where the three branches of government finally meet, the president appoints with the advice and consent of the Senate, and Article 3 judges are ascending to the Supreme Court. That's the point where we have the three branches of government intersect, and all we hear is, I can't answer, I can't answer, I can't answer. This is hypothetical, I can't answer. Definitely something should be done to make those kabuki theaters more meaningful, because this is not the way to go. And if my esteemed colleague will rely on the Ginsburg rule, then I will just point out, well, not without detailing that the NPR called the Ginsburg rule false advertising by the GOP, showing how Ginsburg herself answered literally every question, the most responsive nominee ever in the hot seat for the Supreme Court. And Gorsuch was the least responsive. Of course, they haven't yet come up with the numbers for Judge Kavanaugh, but I'm sure he will be either near or even more unresponsive than Gorsuch. And finally, the future. The future of the Supreme Court is now at the hand of a person that you all heard his opinions. In the past, weaker opinions were enough to derail the nomination, as has in fact happened with Bork. And the most interesting thing is Judge Rodriguez has shown us that this is the Kennedy seat. So the Republicans are really playing the long game here. They waited 31 years, very patiently, and after this article is called the Bork nomination, the New York Review of Books of August 13, 1987. They waited patiently 31 years, and now they're ready again to put a new Bork on the court. But public opinion has shifted, and more importantly, procedural rules have shifted, so 51 votes are enough to confirm, and not 60 as was at the time of Bork. So if you're concerned about consumers setting up to big businesses, to women to control what happens to their bodies, to people who sell weapons for mass killing to be regulated, to lawmakers to greenlight discrimination against gay, lesbians, and transgender Americans, for industries to pollute the air and their environment with impunity, and for the wealthy to purchase more political influence and power under the First Amendment, this is your guy. But if not, maybe you should reconsider. Thank you very much. And it is now, sorry, do you want to introduce him? And it is now my great pleasure to introduce my colleague, Professor Jonathan Adler from Case Western Reserve University. He's the inaugural George, is it Verhey? Johann Verhey, I'm so sorry. A Memorial Professor of Law and Director of the Center for Business and Law Regulation at Case Western Law School, where he teaches courses in environmental law, administrative law, and of course constitutional law. Professor Adler is the author and editor of 7 books, including Business and the Roberts Courts, Oxford University Press 2016. His articles appear in many distinguished publications. In addition, is a very active Supreme Court bar influential voice. So with that, please welcome Professor Jonathan Adler.
Thank you. I apologize for being a little late. I was actually teaching not Marbury, but Martin versus Hunter's Lessee, which Oliver Wendell Holmes thought was a more important case than Marbury anyway. So that's where I was. So I want to very briefly say a little bit about the court as it stands right at this moment, the likely influence that Justice Kavanaugh will have on that court, and what we can say about what we should expect from Justice Kavanaugh. Before any of that, let me say a little bit about the hearings. One of the benefits, I guess, of having eye surgery is I got to sit and watch pretty much with one eye, albeit, pretty much the whole thing.
Your left eye.
Last week. And I'll say a couple things. One, about the sorts of questions and answers that are asked. Those that know how to ask questions that are designed to elicit information had no problem getting information from Judge Kavanaugh, as has been the case with prior hearings. Those that were interested in either hearing themselves speak or in creating gotcha moments didn't get much information. And unfortunately, that is the nature of the process. But there were quite a few instances where we got to hear the nominee talk about his judicial philosophy, talk about what he understands originalism to mean and how he applies it, how he evaluates precedent, the role of Federalist Papers in informing judicial decisions, and about all the various articles that he's written that he was asked about in his prior decisions. And this is entirely consistent with what we've seen from prior nominees. In the case of Ruth Bader Ginsburg, for example, she had written law review articles about the extent to which the Constitution protects a woman's right to terminate pregnancy, and so was able to answer questions about the meaning of those articles, just as Judge Kavanaugh answered all kinds of questions about the meaning of his Minnesota Law Review article, his Harvard Law Review article, his Case Western Reserve Law Review article. He didn't get a lot of questions about that, but I had to mention it because in those cases, the nominee has already expressed a view on something and can be asked to clarify and explain that, just as they can be asked to clarify or explain a decision that they've issued. The line that has been drawn fairly consistently for the past 20, 30 years is that in the position, where a nominee is in the position as supplicant, in effect, asking for a senator's vote to make a statement, particularly one that has not been made before, about what that nominee intends to do, necessarily implicates that nominee's ability to rule neutrally and fairly on a case concerning that subject matter, should that case come before the court. Because the implication of that scenario is, I am telling you, the senator, what you want to hear, so you vote for me. And any nominee that answered that question, either to a senator, or for that matter, to the president, or a member of the White House counsel staff, would be obligated to recuse in any such case that comes forward. And that is a standard that has been applied somewhat consistently in the hearings over the last 20, 30 years. The one area where there's been some fluctuation is the extent to which nominees make a judgment about the extent to which certain past cases are sufficiently settled or sufficiently non-controversial that expressing a view on those cases that has not previously been expressed does not raise the implication of committing the nominee committing themselves to a position in return for a favorable vote. And so, for example, there have been differences about the extent to which nominees are willing to say Griswold, Brown, and so on are on or not settled law. Is that a good process, bad process? I think it's really a function of what the senators make of it. I think there were some, Minnesota Senator Klobuchar, Delaware Senator Coons, who took advantage of the opportunities to really get into and explore what was meant by things that Judge Kavanaugh had written and said previously. There were some, who I won't mention by name, who were really just looking for gotcha moments or for things on the evening news. And the answers, I think, reflect that. I would just note, prior to 1959, nominees didn't answer questions. Prior to 1939, they didn't even show up. And if you go back to the history about why, for example, we had public hearings on Justice Brandeis or Justice Frankfurter, why nominees felt they had to answer questions in the 1950s, and why senators wanted to ask them questions in the 1950s. The history about where this came from is really not one that should make us feel that this is a particularly, or that this process has a particularly noble history. It does not. It has a particularly rancid history. As an educator, I like the fact that an opportunity for a nominee to be able to explain certain things is an educational moment. And I've shared certain clips, for example, with my students, because it is interesting to hear, for example, a judicial nominee explain what they understand originalism to mean and how they, as a judge, would apply that. Because assuming that nominee is confirmed, that tells us something about the behavior, we hope at least about the behavior of the court that nominee will be a part of. But otherwise, it has become a political theater. So that's enough on the hearings. In terms of where the court is now, we've referred to the Roberts Court to date largely as the Kennedy Court for reasons that have already been discussed. Justice Kennedy was in the majority more than any other justice throughout the past 10 years. If you knew where Justice Kennedy was going to come out, you'd know where the court was going to come out. What that meant is that this was a court, I'll use somewhat technical language, but I think it gets the point across. The modal distribution of the court's decisions was conservative. That is to say, the court was conservative more often than it was not conservative. You're just going to count up the cases. In cases where the court split 5-4 along left-right lines, Justice Kennedy voted with the conservatives in 2/3 of those cases. And during his time on the court, this past term, he voted with the conservatives in 5-4 cases every time the court split along left-right lines. That's Justice Gorsuch crossed over to vote with liberals more often than Justice Kennedy did this past term, and he did it once. What's interesting is that Justice
Not
Kennedy,
exactly a trend.
no, Justice Kennedy was like the chief in many respects, most of the time a conservative minimalist. That is, most of the time he was right of center, most of the time he was interested in narrow, small rulings that move the law incrementally. What's interesting is that there are certain issues and subject matter where Justice Kennedy was not conservative, and there are certain subject matter about which Justice Kennedy was not conservative. And that often happened in fairly high-profile areas. But in those areas, because he was so often the deciding vote, the court would neither be conservative nor particularly minimalist. So in the area of the First Amendment, for example, Justice Kennedy was the most speech-protective justice on what I think can fairly be characterized as the most speech-protective court in our nation's history. That is to say, more things are protected as speech today than ever before. It is a universe of types of expression that has been ever expanding. And Justice Kennedy was as fervent about protecting expression of the sort that is generally favored on the left as that sort of expression that is generally favored on the right. And in those areas, he wasn't interested in drawing little lines or balancing tests or incremental decisions. He was interested in just sweeping away the field. So he wrote some opinions saying, we're done with identifying categories of expression that don't receive protection. There are some that we have to recognize through history. Don't ask us to recognize any new ones, no matter how much they look like the old ones. Obscenity is about sex. It's not about grotesque torture of animals for purposes of sexual gratification. That's a different category. It's fully protected. Similarly, Citizens United. Not interested in little lines, interested in sticking with the field. And of course, in cases like Obergefell, Lawrence, Romer, Windsor, Justice Kennedy had a view of individual liberty that was quite expansive. And if you read those opinions, not only are they not particularly conservative, as we've come to understand that term in terms of methodology, they're not particularly minimalist. These are broad, sweeping opinions. And so we see that with the Roberts Court. The other thing about the Roberts Court to date, which is also potentially influenced by the replacement of Justice Kennedy, is that the Roberts Court has been more of a status quo court or more of a stare decisis court than any other post-war court. That is to say, the Roberts Court both overturns prior decisions of the Supreme Court and strikes down federal legislation at a substantially lower rate than did the Warren Court, the Burger Court, or the Reynolds Court. And it's not close. I think that can be attributed in part to Justice Kennedy. I think that can be attributed in part to Chief Justice Roberts and his preferences for minimalism. But certainly changing the makeup of the justices does not only changes the votes, but it also changes the internal dynamics. And so something really important to watch for going forward will be, does changing the dynamics internally mean that the court becomes less concerned about precedent, less deferential to Congress than it has been over the past 10 years. Now, in terms of Judge Kavanaugh, what can we say? We know he's a conservative judge. There's no question about that. President Trump said he was going to nominate conservative jurists. That is what he has done quite consistently, both to the Supreme Court and to the lower courts of appeals. District court nominations, as you might expect, have been more of a mixed bag given the politics of district court nominations. Justice Kavanaugh, by his own account in the hearings, said that he is an originalist, and by that he understands that to mean that he believes that the public meaning of the constitutional provisions at the time they were ratified by the people are what those provisions mean, and the meaning that judges should apply. That insofar as that text is indeterminate or does not fully answer questions, he said that he believes that structure and history are important guides to helping suss out that meaning, and then of course precedent plays a role as well. One thing that's interesting about this is that it was hard to find Judge Kavanaugh actually on record saying that, using the word, the label originalist prior to the hearings, but he did, and that I think that is notable. In terms of specific areas of the law, he's been a judge on the DC Circuit for the last 12 years. He's a bit of an administrative law jock. As someone that spends a lot of time in administrative law, I kind of like that. As I try and explain to my wife unsuccessfully on a regular basis, administrative law is really where cool stuff happens. She still thinks it's like torts and
Keep
stuff
trying.
like that. I will. But he's been on a court for the last 12 years that gets a steady diet of cases challenging federal agency action, and he not only has a tremendous number of decisions in that area, he has some fairly extensive decisions, and ones that have been quite influential. It's been noted that he's only been overturned once by the Supreme Court. There's a bit of randomness in that number. What's more significant is the number of times he has written opinions on the DC Circuit that have been vindicated by the Supreme Court, either by the court affirming his decisions, or by the court overturning decisions that he dissented from, or even the court in complete other different cases actually reaching out to cite him and his rationale and his authority in justifying their decisions. The Supreme Court has even done that with some of his dissents. A dissent he wrote on the issue of prudential standing, the Supreme Court, in a unanimous opinion, cited as an authority for its analysis. He is a judge who, as a lower court judge, especially in the area of administrative law, already commands the attention and respect of the other justices. That's not something every appellate judge can say, and that makes me believe that he's someone who will have a disproportionate influence on the court. He won't just be one of 9 in terms of his votes, because at least on these areas of law, the court already cares what he has to say. And when he's in the room at conference, I would expect that influence to increase. 2 other brief things worth noting, or 3 super quick. One, in the First Amendment, it appears that he shares Justice Kennedy, for whom he clerked, Justice Kennedy's broad view of the range of things that are protected by the First Amendment. We see a wide range of cases, including some commercial speech cases, some campaign finance cases, in which he adopted a fairly expansive view of speech protections And I think that is area where we may see some continuity. Criminal procedure, I think it's going to be a bit more uncertain. Justice Kennedy tended to be more of a pragmatist than a formalist on criminal procedure cases. What that means is, in cases like involving things like the Confrontation Clause or precisely what's a search and so on, Justice Kennedy was very concerned about not making things too difficult for prosecutors, not too difficult for cops. Let's think about the pragmatic concerns that have to be taken into account in the field and so on, as opposed to, say, Justice Scalia, whose views on criminal procedure were, if there's a bright line rule in the Constitution, I'm going to enforce it. If that means some lab tech who did a blood test in Montana has got to drive across the state to just show up to court to verify a particular document or a particular test, too bad. Confrontation Clause requires that. It's unclear where Justice Kavanaugh is going to fall out on some of these cases, but there's reasons to believe he might be closer to Justice Scalia than Justice Kennedy. There's even reason to believe that for criminal defendants, he will be more favorable to criminal defendants than a Justice Garland would have. In one of the few cases in which they split, a case called Burwell, on the issue of needing to show mens rea, Justice Kavanaugh wrote a dissent joined by Judge Tatel, who's a very liberal judge on the D.C. Circuit, arguing that the prosecutors have to do more to show mens rea than the majority, joined by Judge Garland, would have required. Lastly, it is interesting that Judge Kavanaugh has identified Chief Justice Rehnquist as one of judges that he aims to follow, and in particular points to Chief Justice Rehnquist's view in a case called Washington versus Glucksberg. That's interesting because there's a tug of war on the court about how to think about the protection of fundamental liberties, especially unenumerated rights, between the framework that Chief Justice Rehnquist laid out in Glucksberg, which is a very historically contingent, a backward-looking analysis. We protect those things that are really deeply embedded in our nation's history, as opposed to the broader analysis that you, for example, see in an opinion like Obergefell and embraced by Justice Kennedy. What's interesting is if you go back for the last 15 years, you see the court kind of ping-ponging back and forth between embracing this broad analysis that you see in Obergefell and seeing a Glucksberg analysis. So McDonald uses Glucksberg, Obergefell didn't. The court's going back and forth. There's reason to think that Kavanaugh will be on the Glucksberg side of that. I've probably gone on too long. I'll stop there.
That's fine. Thank you. I would like to ask each of our fellow panelists, if you had been a senator there in the Senate Judiciary Committee and you had the chance to ask one question of Judge Kavanaugh and be guaranteed a truthful answer, what would that question have been? Professor Khalid.
Wow. I was not prepared for this. But,
That's the best kind.
I know, but if you could sit on appeal on your own Garza decision that talked about abortion on demand, what have you written as a Supreme Court justice?
You wouldn't have gotten an answer.
Well, you said.
Yeah, I mean, I would have played the hypothetical. Yeah, no, I would have asked, and there were some questions like this. I would have asked something like, it's well established that the 14th Amendment provides protection of certain liberties that are not explicitly enumerated, at least not in the text of the 14th Amendment. How would you go about the process of identifying what those liberties are? There's an article written by Randy Barnett and Josh Blackman with a phrase something like restoring the lost confirmation that makes the argument that questions about clauses are better than questions about cases. Because you can actually, because the nominee is freer to talk about the thought process about how they would evaluate a particular clause.
Especially for originals.
Right, but then once you start talking about specific cases, the nominees feel that either it's a gotcha question or that may lead them in the direction of hypothetical or something that may come before them, whereas you could talk more broadly about what does equal protection mean? How do we understand when it is that the government does not provide equal protection under the laws? And I think there were a handful of questions like that, and I wish more senators would do that.
Thank you. We have Carrie with a microphone. Does anybody in the audience have a question they'd like to ask our panelists? Don't be shy.
I hope I'm not putting any one of you on the spot too, but we all
haven't been
know
nominated to the court, so go ahead.
the abortion and the Roe versus Wade case seems to be a real hot button item the senators are focusing in on. For the layperson, it's been a while since that decision came down. What, 74? Is that about
73.
73. Could any one of you really relate the fact pattern that brought that case to, to the issues that came to the court, the underlying trial procedure and appellate issues, and how that case ultimately reached the Supreme Court? Was it on moral grounds, fiscal grounds? I don't know that anyone really knows that.
What did you look at?
I mean, Jane Roe was a pseudonym, was one of multiple individuals who were challenging a Texas statute that prohibited abortion.
What state, if you know?
Texas.
Texas, thank you.
I'm not going to answer all the little details, but some interesting things. So one, it gave me the example I always use to my students to be able to explain the exception for mootness of capable of repetition but evading review. Right? Because as we all know, getting a case to the Supreme Court takes more time than the longest possible gestation period one can imagine. Right? It takes more than 9 months, and so how do these cases not become moot? But the courts recognize that this is a clear example of something that can capable of repetition and escape from review. Because there will, if not Jane Roe, then there will be another woman who will be in the same situation of having a pregnancy that they want the right to.
So apparently Texas enacted a statute.
It was prohibited. It was completely prohibited.
Criminalizing, I take it.
Yeah, I believe the Texas law
Abortion.
prohibited the doctor, not the woman, but it was prohibited. When it got to the Supreme Court, Texas made the argument that not only did Texas have the authority to criminalize abortion under the Constitution, Texas actually argued that it was obligated to, because insofar as the 14th Amendment requires that all states provide equal protection of the laws to all persons, and because the 14th Amendment makes reference to persons born and naturalized when defining citizenship, that contemplates the existence of those that are persons but are not yet born, and that Texas had an obligation to provide equal protection to them. That position, which would be a position that would obligate all states to limit, if not prohibit abortion, got 0 votes and has never received a vote from a Supreme Court justice. But it is a position that Texas put forward in Roe. The court rejected that. It argued that the state had an interest, had 2 possible interests it could put forward in point 2 to justify limiting the exercise of the right, one being the health of the mother, the other being fetal life beyond a certain point. In Roe, Justice
Incest was not a factor?
In Jane Roe's case, I don't believe so. It certainly wasn't an issue for the court. I mean, it wasn't.
But the statute didn't contemplate that exception, which is a commonplace now for.
Right, but these days they're traditionally an exception. The current law today, though, is governed by Casey, which is a 1994 decision, where the court said that we're not going to have the trimester framework that Roe created. We're instead going to say that prior to viability, the state has an interest in protecting the life and health of the mother. After viability, the state has an interest in protecting fetal life. Casey also says, and I think this is important in talking about the Harding v. Garza decision that Casey says explicitly that the state is allowed to favor the preservation of fetal life. In developing its regulations, it just cannot do so in a way that imposes an undue burden on the ability of a woman to exercise her right to terminate the pregnancy prior to fetal viability.
So,
and the real action today is on how much of a burden can there be before it becomes undue, which is not a self-evident test, and to what extent does that burden have to be justified by certain types of state interests? And that's really where the fight on the court is.
okay, at the entry level of the case of the issue, then, did the state actually charge this woman, and was there a trial, or did it go up on stipulated facts?
She was not charged. As I recall, she was seeking a declaratory judgment.
It went through a declaratory judgment.
That's what I recall.
And the same is true for Planned Parenthood versus Casey, the 1992. That's for a case that was mentioned earlier. This is the current law. in the Supreme Court, and Judge Kavanaugh referred to that as precedent on precedent. So it is very important to understand that for him, it was the fact that it was twice confirmed now is very important. The test of undue burden was authored by Justice O'Connor, who prior to serving on the court and intermediate appellate court in Arizona was a legislator. And so this term, which fits a legislative perhaps test, is very vague as a judicial test. And once upon a time when I happened to have the pleasure of meeting Justice Scalia, he bitterly complained about this. He said, well, what does undue burden mean? Like it can mean to you something and to me something else. But for me, when a minor is seeking an abortion right now, she's in prison, she's in United States custody, and she's refused that. If this is not an undue burden, I just don't know what is. I just don't know what is.
Do fiscal issues enter into this because say a woman enters a clinic and she wishes to have an abortion?
It's elective organization.
Insurance probably wouldn't cover it.
No, a non-for-profit organization volunteered to cover the entire expense. Not a cent was spent by the United States.
Okay, thank you.
Two other points, if I may. History buff that I am. Henry Wade, the Wade in Roe v. Wade was a longtime DA in Dallas, and many of you remember the Kennedy assassination. Henry Wade was quite prominently featured. Had Lee Harvey Oswald lived, he would have led the prosecution of Oswald under Texas law for the assassination of the president because it was not against federal law at the time. And if you're interested more on the genesis, no pun intended, behind Roe v. Wade, my bibliography is up there, and Woodward and Armstrong's book, The Brethren, goes into great detail on the work done. In particular, Justice Blackmun, former counsel for the Mayo Clinic, knew or thought he knew all about medical, legal ethics and the intersection thereof, and really put in a lot of work on that. Went pretty much camped out at the Mayo Clinic, going through the books and learning about medicine and how that and the law come together. Many people think he got it right. Many people even now think he got it wrong.
There's a biography of Justice Blackmun called Becoming Justice Blackmun, which is also very useful on that. Relies very heavily on Blackmun's papers.
So one more thing. Right now, the action is with the states. Arkansas, for example, enacted a 15-week ban on abortion. In this state, I believe Ohio is either enacted or in the process of enacting a 20-week viability law that will prevent women from having an abortion after that. Those laws enacted by state legislators are destined to become a case before the United States Supreme Court, and so this is how it will be decided, I believe, very soon, if the court will indeed decide to pick up the case.
Gentlemen, let's move the camera a little higher away from the single issue to the overall court makeup and the predictability of what the court may or may not be doing in the future. We now have, with Kavanaugh's presumptive now nominee or confirmation, we now have two very solid blocks. We've got the liberal block with Breyer, Ginsburg, Kagan, and Sotomayor. The conservative block, certainly with Alito, Thomas, Gorsuch, and Kavanaugh. Roberts has been somewhat of an interesting enigma in the court in a way, although people look at him as being conservative. Having met and spoken with him, he also has a very strong desire to keep the court centered somewhat. And he also has a very strong desire to secure majorities that reflect large majorities, if not a unanimity within the court. Hence what we saw with the slants. We saw that decision coming out in a very limited fashion, but with a true majority that was able to carve out in that case as well. We see that in Obergefell with him coming in. He also came in on Obamacare in a way that the conservatives would not have predicted. Not quite a suitor in this, but at the same token, we look at where he is. Is he predicted to move more to the left in carving out majorities? And would he then, in your mind, Judge, particularly you referenced this, is he going to become truly the architect of the Roberts court moving forward?
I think he will, as I mentioned. I think you put your finger on it. He has a strong concern for the institution of the court and wants to maintain its public standing and its respect in the American constitutional constellation. But he would not have been nominated by, I would suggest to you, by President George W. Bush if he were not regarded as reliably conservative. He is more conservative more often than not, while he does where he can, I think, tack towards the center when it is important to him in terms of maintaining the institutional integrity of the court and the public standing of the court, he'll do that. But I would suggest with the confirmation, the likely confirmation of Justice Kavanaugh, he will not be under much pressure to do that anymore and will be more likely to yield to his general inclination, which is, I think, virtually across the board, to find himself more on the conservative side of many of these pressing issues.
I completely support every word. I just wanted to correct one thing, and you were very well presented and a very knowledgeable question. The Chief Justice dissented and bitterly in Obergefell, and also his authorship of Trump versus Hawaii, days after the court says that anti-religion comments by one commissioner in the slowly state hearing in Colorado is enough to turn void two other judicial proceedings that happened later because it's tainted by this anti-religion stain, and then to write a whole opinion saying that whatever the president said about the Muslim ban means absolutely nothing. I think for some, including yours truly, put a slight blemish on this idea of consistency and the move that Linda Greenhouse and others were predicted to the left. I think Trump versus Hawaii is a landmark decision by the Supreme Court, and I think we should look to the author and to the reasoning behind it.
Yeah, a couple of thoughts. I have a slightly different view on this. First, Chief Justice Roberts is aware of what it means to be chief, and that necessarily imposes constraints and obligations that aren't felt by a mere associate justice. And he, I think, appreciated this in part from the justice he clerked for, William Rehnquist. William Rehnquist in the 1970s was the lone dissenter. He wrote these fire-breathing dissents as an associate justice, often by himself. Yet as chief, he, because of the responsibility that comes with being chief, because it means that anytime he's the majority, he's assigning the opinion, he adopted a very different approach that certainly moderated the sorts of things he would write, and there's certainly reason to believe that he often would keep opinions for himself where he knew the outcome was predetermined, but he wanted to write a narrower decision that might have been written otherwise. And we're certainly going to see that from Chief Justice Roberts. I think we've arguably seen that in some cases already. King versus Burwell, I think, might be an example of that. He consistently is a justice that doesn't like to overturn precedent. Look at his dissent in Wayfair, where he says, I think that as an original matter, the relevant Dormant Commerce Clause precedents were wrongly decided, but there's so much reliance on those, we need to keep it. He goes out of his way to avoid striking down federal statutes, looking at his opinion in the Bond case involving this, it's a bizarre case involving the Chemical Weapons Convention Implementation Act. There's a bunch of opinions he's written where he's gone out of his way to try and preserve the constitutionality of statutes that are challenged, sometimes at the risk of losing other justices to his right in those opinions. I think we have every reason to expect that to continue. He believes that the court should try and do that. And he's been largely successful. A third of the court's opinions in his tenure have been unanimous. The court's only hearing 70 cases a term. Almost every case it takes because there's a circuit split. Only about 5 to 10 cases a year it's taking that were not circuit splits. That means the court is only taking cases that really smart, really thoughtful lower court judges have disagreed about. And for the court to come out unanimous in the lion's share of those cases is remarkable, because just by the numbers, we shouldn't expect that. The court's not taking any easy cases. And when the court splits 5 to 4, about 2/3 of those are along traditional right-left lines, but about 1/3 of those are on different splits. And I think we're going to see more of these different splits as the court begins to focus on issues that aren't the issues that have been front and center going forward. So I think he's going to try and stick to this minimalist thing. That will mean trimming his sails. I don't think it'll mean being less conservative. I think it'll mean continuing with the sort of judicial philosophy that he has exhibited, which is certainly conservative. It's just, where possible, one that tries to go in very small steps. Lastly, on Masterpiece versus travel ban case, coming from an administrative law standpoint, it's commonplace that we are more concerned about the neutrality of decision makers in adjudicated proceedings than we are about the neutrality of individuals that are exercising executive power. So, for example, when the Federal Trade Commission is engaged in adjudication, we care a lot about the neutrality of the decision maker and whether or not they've said things that compromise that neutrality. When the Federal Trade Commission or some other agency is promulgating regulations or exercising quasi-legislative power, we don't care at all. And that very long-standing notion from administrative law, I think, more than accounts for the distinction between masterpiece and trial case.
Okay, well, thank you very much. We don't want to run. I think we're already over time. Thank you to our three panelists. We really appreciate the wealth of knowledge that you guys have been in. Let's give them another round of applause.